Why does the judiciary, which read down Section 377 of Indian Penal Code in 2018 in a landmark Navtej Johar case, want it back? And in what form? That's the key question that we shall be addressing in this video. But before we start, I have something important to share with you. Today, I have completed 14 years as an educator. And you ask anyone, it is not easy to survive these many years in UPSC coaching industry. And to celebrate this personal milestone, for the next 3 days, beginning Monday, I shall be mentoring those students for free. Whatever doubts you have, whatever concerns you have, should you wish to get your concerns addressed by me, all you need to do, fill this form which is provided in the video description as well as in the comment section, and let's meet and address your civil services examination preparation requirements. Now let's get started and let's look at Section 377, which was part of Indian Penal Code, and this was enacted during the colonial period in 1860. What this Section 377 basically said, whoever voluntarily has carnal intercourse which is against the order of nature, it is a crime. Now what is this carnal intercourse against the order of nature? Any sexual interaction which is not peno-vaginal in nature, which does not involve the two organs of male and female. Any such interaction which is not peno-vaginal in nature, that is a carnal intercourse against the order of nature, and as such is a crime. And you have been booked under this crime, you can also be sentenced to life imprisonment. This Section 377 was particularly used to target LGBTQ community, lesbians, gays, bisexuals, transgenders, queers, intersex, asexual individuals. So individuals who are in a homosexual relationship, they were deemed as criminals, and ultimately they will be booked under the law and they will be prosecuted. The year was 2001. One non-governmental organization, Naz Foundation, approached the Delhi High Court with a plea that please decriminalize homosexuality, this adult consensual sexual activity between the same sexes. Finally, a two-judge bench of the Delhi High Court in 2009 gave the verdict. Justice A.P. Shah was one judge, Justice Muralidhar was the other judge. They said this Section 377 is unconstitutional. Why? Because it violates the principles of equality enshrined in the Constitution. This violates right to life and personal liberty, which is mentioned under Article 21 of the Constitution. So in a landmark judgment in 2009, a two-judge bench of the Delhi High Court decriminalized homosexuality and struck down Section 377 of the Indian Penal Code. And you would know, once a matter is decided by a high court, you can file an appeal before the Supreme Court. But before that happened, Election Commission of India comes into the picture. This was a different election commission. Mr. Gyanesh Kumar was not the Chief Election Commissioner. And what Election Commission of India did, it provided options. Options in the sense, before that, if you had to enroll as a voter, you had to mention whether you are a male or a female. Only two options were provided. But after this Delhi High Court verdict, Election Commission of India steps in and decides that if you want to register, enroll as a voter, we will give you a third option as well. If you're not identifying yourself either as a male or a female, we will give you another option. You can register under others category. But then in 2013, in Kaushal case, what the Supreme Court did, it decided to overturn the Delhi High Court judgment. Basically, the Supreme Court recriminalized homosexuality. Why did the Supreme Court recriminalize homosexuality? Few arguments were given. The Supreme Court said Section 377 is part of the Indian Penal Code. And since Parliament, independent India's Parliament has started functioning, This Indian Penal Code has been amended umpteen times, numerous times. So if you want to make any changes in this law, for that the ball is in the court of the parliament, not the courts. It is another matter. When the same parliament enacted NJAC, the Supreme Court struck it down. It's another matter when NCRT books are written which speak about corruption in judiciary, the Supreme Court bans that particular book. But in this particular case, the Supreme Court said it is for the parliament to decide whether homosexuality should be decriminalized. This cannot be done by the courts. Argument number one. Argument number two, Supreme Court notoriously, regrettably, said that LGBTQ community is a minuscule minority. And for such minuscule minority, we cannot be changing laws. Another argument. Another argument. Supreme Court was told, my lord, this section 377 has been misused, overused, hyperused, abused to target the homosexual couples, to target their right to love, to target their dignity. The Supreme Court said, and whether you agree with this or disagree, you let me know. Supreme Court said if there is a misuse of a law, just because a law has been misused, that does not make it liable to be struck down. If a law has been misused, that's the problem of the parliament, not the courts. That's the problem of the police, not the courts. Long story short, Section 377 of Indian Penal Code, which criminalized homosexuality, it was decriminalized by two judges of the Delhi High Court. Matter went to Supreme Court on an appeal. Supreme Court said no, Section 377 is back. Homosexuality is criminalized again. It was also argued before the court. And there are some sections of our society who say homosexuality is a disorder. And this disorder needs to be treated. For example, Baba Ramdev famously or notoriously once said, bring these people to me, I will treat them because this is a disorder. If it is a disorder, American Psychiatry Association way back in 1973 said homosexuality is not a disorder. World Health Organization in 1992 also said homosexuality is not a disorder. Our own law, the Mental Health Care Act of 2017, it explicitly prohibits discrimination on the grounds of sexual orientation when it comes to mental health. But even then, homosexuality was criminalized. Finally, in a landmark case in 2018, a 5-judge bench of the Supreme Court, a constitution bench of the Supreme Court had to decide whether homosexuality is a crime or not. And in this case, a landmark judgment was given. Supreme Court decriminalized homosexuality. And there was a flavor of South African constitution in its judgment. Justice Deepak Misra was the Chief Justice of India. He spoke about South African constitution because South African constitution's vision is that of transformation. There is something called transformative constitutionalism, which means this. If there is a social disorder in a society, can constitution be used to convert a society from oppression into liberty? Because through laws, you cannot change the psychology of the citizens. You cannot change the mindset of the people. But even then, we need a constitution, we need a supreme law which can transform a particular society. Even if there are people who are against homosexual couples, even if there are people who say homosexuality should be a crime because it is against Indian culture, it is against our religion, it is against our sabhita, even then constitution can be used to transform the society because we believe in the ideals of equality, where there should be no discrimination on the grounds of sex, which includes sexual orientation as well. Justice Deepak Misra, he spoke about principle of non-retrogression of rights, which means once a society has been given a set of rights, We cannot regress from those rights. We cannot take back those rights. In a sense, if Constitution has given us equality, liberty, freedom, justice, there is no place for discrimination on the grounds of sexual orientation. If we decriminalized homosexuality by a two-judge bench judgment in the Delhi High Court, you cannot subsequently recriminalize it, because then you are regressing once we have reached a particular set of rights. Also, you should remember that another landmark judgment was given by the Supreme Court in Nalsa case, 2013-2014. In this case, Supreme Court recognized transgender as a third gender. That was a remarkable verdict, because till that time we were only looking at it in terms of binaries: male, female, boy, girl, man, woman. But there is a diversity in terms of our sexual orientation, and Supreme Court said transgender is a third gender that should be recognized in India. Once we have given these rights, we cannot snatch these rights again. Justice Rohinton Fali Nariman, he was another judge on this bench. He said fundamental rights which are mentioned under part 3 of the Constitution, this chapter is like a North Star in our universe of constitutionalism. North Star, benchmark, North Star which was used for navigation purposes. Similarly, any evil in the society, we have to eradicate those evils keeping in mind fundamental rights, because fundamental rights are sacred in our holy book known as the Constitution. Not your personal morals, not your religious symbols. Our Constitution is supreme. Fundamental rights like a North Star of our constitutionalism. When in Koshal case, the Supreme Court recriminalized homosexuality, one argument that was given by the Supreme Court was presumption of constitutionality. What does that mean? That means this: when a law is enacted by a parliament and then this law is challenged before the courts will assume that this law is constitutional. It is for the petitioner to prove that the law is unconstitutional. Just like in criminal cases, if you're accused of murder or rape, the courts will assume that you are innocent. It is for the prosecution to prove that you are guilty. And it is difficult to prove that you are guilty. Similarly, when a law is enacted by the parliament and it is challenged in the court will assume that the law is constitutional. Why? Because it has been enacted by the parliament. Parliament consists of elected representatives of the people. How can those who are elected by the people, who are accountable to the people, make a law which is against the people? That's the assumption. Long story short, presumption of constitutionality. That when a law is enacted by the parliament, it will be presumed to be constitutional. It is for the petitioner to prove that this law is blatantly unconstitutional. And this was the argument given by the Supreme Court in the Koshal case. There is presumption of constitutionality. That Indian Penal Code is also constitutional. Section 377 is also constitutional, because after all, it is enacted by the legislature. Justice Nariman said, but this is not an ordinary law. This is the law passed by a colonial government, by a foreign regime. And a law which is passed by a foreign regime in a colonial government, there cannot be presumption of constitutionality. Hence, this law is unconstitutional. Walter Benjamin writes on the concept of history, there is no document of civilization which is not at the same time a document of barbarism. This may be a document, Indian Penal Code. This may be a document providing punishment for those who are committing crimes, but the same document can also be the document of barbarity, particularly for those who identify themselves not as male or female, as a third gender. Justice Chandrachud, who was also a judge on this bench, he said civilization has been brutal for the members of the LGBTQ community. And Justice Indu Malhotra, a woman judge on this bench, she said, we owe these members of our society, LGBTQ community, an apology because we have violated their rights. We have disregarded their dignity. And as such, in this landmark verdict, Navtej Johar, Supreme Court decriminalized homosexuality. And Supreme Court basically said, right to love is a fundamental right. And Supreme Court also spoke about constitutional morality, not the social morality. For example, you, me, others who are watching this video, they may say that homosexual relationship is against our culture, is against our social norms, is against our family as an institution, is against our religion, is against our morals. But do we have to look at your morals, or do we have to look at the morals which are propounded by the Constitution? Constitutional morality, which is of equality. Why should we discriminate amongst the citizens based on whether they identify themselves as straight or gay or lesbians? We have to provide equality. We have to provide dignity. We have to provide freedom. So constitutional morality will trump over social morality. This was when constitutional morality was invoked to read down Section 377. Section 377 was not struck down, it was read down. What does that mean? Now listen to me carefully. Insofar as Section 377 was used to criminalize consensual adult relationship, it is not a crime. Which means if there is a man and a man, but they are in a consensual relationship with each other, they have right to love, they should not be criminalized. Their relationship should not be criminalized. Only if it is consensual. What if it is not consensual? Which means what if there is a man who is raping another man? Section 377 will be invoked to prosecute this man who is a rapist. That is why if Section 377 was struck down, then there is no law which can criminalize those men who rape other men in a non-consensual relationship. That is why Section 377 was retained. It was read down, not struck down. Which means gay relationship, lesbian relationship, if it is consensual, it is not a crime. But what if there is an element of force, coercion? It is a crime under Section 377. Section 377 will continue to operate, but not to criminalize homosexuality, but to criminalize rape. Similarly, bestiality, sex with animals. Can animals give consent? No. In absence of this consent, informed consent, if you are having sexual relationship with an animal, it is a crime. So Section 377 will be invoked to prosecute you. If there was no Section 377, we cannot criminalize this rape. We cannot criminalize bestiality. That was the status of Section 377 once it was read down in this landmark Navtej Johar case. But then something else happened. Indian Penal Code was replaced with BNS, Bharatiya Nyay Sanhita. Indian Penal Code replaced with BNS. But in BNS, there was no equivalent section similar to Section 377. No equivalent section. Which means what? Here is a man who is raping another man. Previously, Section 377 could be invoked to criminalize this activity, to prosecute this man for rape. When there is no Section 377, there is no similar section in BNS. That means if a man is committing rape on another man, you cannot be charged with rape. Maximum you can be charged with is grievous hurt. For that, the punishment is less, not the life imprisonment. Bestiality, sex with animals is a crime under Section 377 of Indian Penal Code. But BNS is replacing IPC. There is no similar section as Section 377, which means now if a man is having sexual intercourse with an animal, which section will you invoke to prosecute this man? There is no section. On top of that, something else. Marital rape is not a crime. It's not a crime. Because the assumption is once an individual has married another individual, you have given consent for your entire life. There is no rape. But what if there is a man who is performing anal sex on his wife? Section 377 could have been invoked. Why? Because Section 377 is carnal intercourse against the order of nature. Anal sex is a carnal intercourse. It does not involve, it is not a peno-vaginal interaction. As such, if there is a man who is performing anal sex on his wife, although marital rape is not a crime, but this section 377 could have been invoked to prosecute this man because you are committing carnal intercourse against the order of nature. But with BNS replacing IPC, and there is no equivalent section such as section 377 in the BNS, that means all these activities, for that there is no punishment under BNS. Matter went to the court. My lord, please direct the parliament that in absence of section 377 protection in the Bharatiya Nyaya Sanhita, please restore these protections. In 2024, August 2024, the Delhi High Court referred this matter to the parliament because there is separation of powers. Judiciary cannot legislate. The job to make laws, the job to legislate is with the parliament. In absence of section 377 type protection in the BNS, what can the court do? Court directed this matter to the parliament. Please consider. And once this petition was dismissed, when the matter was given to the parliament, it's been more than 1.5 years and parliament has decided not to act. Parliament has not amended the BNS to restore section 377, to criminalize other activities, not to criminalize homosexuality again, but to criminalize other activities. The petitioner approached the Delhi High Court again. My lord, even after 1.5 years, we haven't seen any movement on part of the parliament to give us these protections which were previously under section 377. And the Delhi High Court said, now 1.5 years is a reasonable time to take any decision. However, no decision has been taken. In view of this matter, since no decision has been taken, we are reviving the previous petition. And now that we have revived the previous petition, we are seeking an affidavit from the center. What are the steps that you are taking to comply with our orders, to comply with our previous direction, that you should consider making these safeguards again in BNS to ensure that the law, the absence of this law, will not lead to violation of rights and dignity of the individuals. Long story short, section 377, it was not struck down in Navtej Johar case, it was read down. When it was read down, that means there were some other activities, for example, bestiality, which was still a crime under section 377. Now with BNS replacing the IPC, there is no similar provision, which means anal sex performed by husband on the wife, there is no protection. Bestiality, there is no protection. Similarly, rape of a man by a man, there is no protection. Because our rape laws, anti-rape laws, are not gender neutral. Rape is a rape only if it is committed on a woman by a man. So a man is said to have committed rape if he rapes a woman. Man is not said to have committed a rape if he rapes another man. We need such protection back. And for that, we need section 377 back in BNS, Bharatiya Nyaya Sanhita. And in all likelihood, either the parliament is going to amend the BNS to provide these safeguards again, or judiciary is going to restore these provisions. For that, maybe if the matter goes to the Supreme Court will use Article 142 in order to give complete justice. What do you think of this matter? Should these protections be brought back in the BNS, or we don't need these protections at all? Later on, in Suprio v. Union of India 2023-24, the matter again went to the court. My lord, now that we have a right to love as a homosexual couple, my lord, now that you have recognized in the Nalsa judgment that transgender is a third gender to be identified in India, the next logical conclusion should be we should be given a right to marry as well. But a 5-judge bench of the Supreme Court, headed by the then Chief Justice of India, Justice Chandrachud, decided that there is no right to marry. If at all right to marry is to be given to the homosexual couple, that should be given by the Parliament. But then what will happen to this principle of non-retrogression of rights? Rights once given should not be taken back. Should there be a right to marry for the LGBTQ community as well? Do let me know in the comment section and subscribe to our channel if you haven't yet. Thank you for watching. Take care.